Can you hear me, Amelia?
Yes, I can.
Okay.
Amelia, this one's open to the public, right? Okay,
Yes, it is.
thank you. Thanks, Ed, for coming back. I gotta grab this call really fast.
It is 4 o'clock, so are you ready, Christine?
I'm ready.
Okay, we can get started at any time, Mr. Farrell.
Okay. Should we start with the first item?
Yes, thank you. And thank you everyone for joining Policy Committee this afternoon.
Okay. So this document has a long history. I'll just briefly outline it. Back in about 2010, the commission, or 2012, the commission embarked on a journey to try to be more proactive and employ innovative principles such as just culture in its disciplinary work. And so the commission entered into a collaboration with the Foundation for Healthcare Quality to set up a process whereby the foundation would encourage, and the commission would encourage, institutions to adopt communication and resolution programs, and then to ask the institutions, once they had a case that went through a CRP process, to apply for certification from an event review board within the Foundation for Healthcare Quality. And so that process started maybe about 2015, 2016. The cases that were submitted were very few, maybe 26 in about 5 or 6 years, and then the pandemic hit and the cases stopped coming through. Before that, when the cases came through, the institutions had a choice of whether to submit the certification report to the commission. And that was done primarily only when the commission was looking at a complaint against a physician who was involved in an adverse event that resulted in a communication resolution program, and then certification. So 6 of those came through. And if you want me to back up here, I'm happy to back up. I'm assuming that everybody has read this and has some familiarity with this process. I'm just giving you a brief history. Only 6 cases came through. All these cases were closed. We've logged them. We expected to get dozens of cases. We never got them. And then during the pandemic, institutions stopped providing cases to the certification board, the event review board, because institutions had other priorities. And then funding has always been an issue within the foundation to fund this work, to fund the certification process. They talked about transferring this work to the Hospital Association, and I found out 2 days ago that the legislature in its last budget provided funding to hire a manager to run the program, to run the certification program within the foundation. So there was a lull due to lack of funding and the pandemic and other priorities. But now the funding issue has been resolved, at least temporarily. And it looks like the certification program is going to get back on its feet and start running again. So my view of this whole process has changed just in the past 2 days. And what I would like to do is take this document that you have in front of you. I'm happy to answer any questions about it, but it needs to be updated. It needs to be rewritten. And I think we have to form a work group to meet with the foundation to revise our statement of understanding, which was not included in your materials. I'm happy to send it out to everybody. But we need to revisit our relationship and decide exactly how the commission is going to collaborate with the foundation and exactly what we're going to do, considering that the program is back up and running. If you read the document, you'll notice at the end, there's some promises made that were never kept by both sides. And it was about once cases go through the certification process, that the commission and the foundation, and with help from the hospital association, would start disseminating lessons learned statewide. So when a medical error occurs and we get a root cause analysis and we learn what contributed to the error, then the three groups would get together and create some type of communication that would go to all hospitals and maybe all practitioners statewide to share a learning that occurs in one institution can be shared with all the other hospitals in the state. That never happened. So that's one of the things we need to talk to the foundation about. Is that even viable anymore? Anyway, I'll stop there. I brought this forward because it's up for review, 4-year review. Actually, the document is 5 years old. The process is much older than that. But I wanted to get your feedback on this. But my recommendation is that this be rewritten after a meeting with the foundation to sort all of this out and see exactly what kind of collaboration we have. And that would apply to the procedure that's in your packet as well, which provides the nuts and bolts of how the commission will process cases that have gone through the certification process.
Thank you, Mike. That's why I sent you that email with the question mark of, is this even a viable process right now? So I think it's great to put a work group together.
Well, I do too, because there may be funding, but to be honest with you, I've been working on this project since I came to the commission, and it's always been kind of a one-sided thing. The risk managers at the different hospitals never wanted to share any kind of lessons learned. So I don't even know if that's viable or will ever be viable. Yeah. And we've done our bit on when we get certification of cases, but then that just died. And we have this policy in place, but we haven't used it for at least 3 or 4 years. I don't think we've had anything since the pandemic. And I don't know that it's just funding specific. It kind of, even when there was funding, there wasn't a lot of movement on this. So to me, I think it should be rescinded and wait to see what the foundation does.
I also wondered about that. Do we just kind of scrap it, so to speak, and wait? Dr. Domino has her hand up.
No, I was just going to ask about the funding, because it's not just one person who's involved in it. I thought we were trying to do some of this ourselves, using their principles with our investigators, right? And our own people, our commissioners. And it just seems, as far as publishing what went wrong, I think is really important. And I've done that my whole career. I don't know, a lot of you may not know, but I run a project through the American Society of Anesthesiologists that studies adverse outcomes through closed malpractice claims, and I go to malpractice companies and do it. We write articles there. You can write little vignettes and you change a lot of the data about it. Like you change the sex or what procedure or this or this or this. But there are ways that we could do as a commission to put on our websites interesting kind of things. You can make up your own details, like a drug error. Those happen all the time, right? So one could do that kind of thing. And they don't necessarily aren't a report of a specific case, which with the details, all of that case, that particular case, which is people don't want to provide, right? This is where the problem with the risk managers are. So I don't know. I mean, I think it's important to have, I like the whole part, I mean, of the, medical error and statement about that, but I think we need to see what really happens with this foundation. And I do like Tom Gallater. His office is a floor below me, but I don't know. It just seemed like the big issue tends to be the risk managers at institutions.
Since there's funding for this now, does everybody here feel that it's worth putting that group together as
I do.
like suggested?
I think it's a
Yeah,
work group's
work
fine. I
group,
just
yeah.
don't know what it's going to lead to.
Well, that, yeah, I guess we'd have to see once it came together. Somebody else has their hand up. Scott.
Scott Rogers, yeah.
Yeah, I don't want to repeat anything that's already been said, but this is the kind of thing that I was hoping to participate on. There are an incredible amount of institutional barriers that would prevent this process. I mean, the risk managers, which really are the lawsuit prevention department, also patient advocates. I always advise my clients and prospective clients that they should not speak with the patient advocates from the hospitals or clinics, because their role really is to collect information and feed it to the risk management department. And there's a very adversarial relationship between risk management and the malpractice attorneys. There are statutory things that should be implemented, that there are kind of gaps in what does it mean that this is not discoverable versus what is not usable in lawsuits. And I wholeheartedly embrace this type of approach, but I also want to be realistic that there's a lot that has to happen before this can become a standard operation. But I support it, and I would be interested in working on it.
Well, you
Scott-
have the Rome committee was for this specific
Right.
thing. So
Yeah.
you've taken that committee and you're still on it, and you've changed it to the hero committee, but maybe you could
It's
focus a
still
couple
part
of
of it, right?
meetings
This is part
on
of it.
this, right? Yeah.
Scott, I'm wondering, if I know why they don't want to do it. You release this information immediately, but a lot of times these claims are settled by the time probably it reaches the board. I mean, it comes to the board, right? It takes time after medical errors to have investigations done within the institution. It takes time for the injured patient or the family of the injured patient to file a claim with a to hire a malpractice attorney. And that's where these things ultimately happen. In my assessment, at least at the University of Washington, in these things, it's in the settlement process. But if you're just talking about having an error and having it picked up immediately before it goes through any medical legal action, I don't think, that's a problem. But if it's already been through the medical legal action, sorry, my here sounds weird for me. Anyway, I just wonder if trying to approach, if we want to get some of these cases, ones that are already settled, right? So that sharing the information and changing the identity of the information, and perhaps altering, as I said, some of the details that don't take away the particular issues involved it could be done to, add some information to our educational materials from the commission. Can
Well,
it, Mike?
Micah, if you are on, I mean, Jimmy Bush has tried to do this for a long time and can get no one to write the article or provide the information. So we're all about, we would love to print things in like our newsletter, but no one will provide, write them for us. And we've had problems getting the information. We've had problems like some people say, well, take the paper that this respondent wrote because it was really good and publish it. And we haven't been able to do that either, if I'm correct in that. Is that true, Micah?
Yeah, I mean, there's always been a little bit of heartburn as it goes through the process, specifically for someone who would write, this is my lesson, my learning or whatever, and trying to put that into the newsletter. That's an example that WPHP has actually done fairly successfully. So I think we could probably do the same. There is always a legal concern, I think, expressed by our attorneys about potential, what do you do when someone publishes something and lo and behold, they may get into trouble later on? Is that something that taints the medical commission or not? I think sort of redirecting, I do want to kind of have a little bit of a discussion about the origins of this whole thing. Dr. Domino, you talked about Dr. Gallagher, and I was involved, not quite as much as Mike Farrell was, for sure, in the beginning of this, but also listening to what he was trying to do and use the Greenwall Foundation grant, as well as his research partners, Michelle Mello and Bill Sage. And we have to remember that the basis of all this is to one day do away with the need for a medical regulator. And that was quite transparent in some of what they were saying in the beginning. And I see you shaking your head, Mike, and we're going to disagree. Frankly, because that was openly stated by Bill Sage in one of his presentations when he was presenting at FSMB. The idea that not that they were trying to get rid of the regulator, but they were trying to make them superfluous and not needed, because the self-regulation concept that is applied in other countries would be able to be used here. I don't think that's necessarily a bad concept, but it still has to be proven out as effective and useful before we can actually do anything. So I think remembering that was sort of the thought experiment at the beginning, as what part of what informed the CRP process and what they were trying to do is really effectively self-regulate, or get the profession and the hospitals to work together to self-regulate, I think is something we need to remember as we move forward, trying to do either the CRP with high reliable organizations and what the future could hold for this process.
I remember when I first joined the commission, this was happening in the Rome committee, which I joined. I also went to a talk about it. I don't remember exactly where it was held now, but I believe Dr. Chung was there and really supporting this. I think you were there, Mike. I don't know for sure because I hadn't really met everybody yet, but I wanted to go hear about this. So this has been kind of rolling around from Rome committee to now. And when I read this, I thought, wow, this has never just really taken off at all. So, and now we've got this funding and a person in charge, so to speak, to try to get this moving, and hopeful that we'll collaborate with them is what it sounds like. And
well, and we're kind of downstream, they had funding for a person several years ago. And the foundation was the perfect place for them to work through. And then we would get, if we got a case, then we would go and use our process. So we're kind of downstream. And so I think, to me, the ball is in the foundation's court, and they need to figure out what they're going to do with that. And then, we could do what we did before, should that happen, but maybe they're going to take a different approach. We don't know.
mm-hmm.
Dr. Domino has her.
Dr. Domino has her hands up.
Oh, sorry,
Yeah,
Dr.
I
Gardner,
was
go
just
ahead.
gonna respond to Micah. I know a lot of people nationally who are in this area, and in terms of basically trying to, it deals a lot more with the medical legal issues, that it costs a lot of money for, that's wasted on medical legal cases. It's wasted on attorneys. It's wasted on all the experts and everything. And what it does, what the institutions and big institutions do this, if there's a bad medical error case, what they come in is a communication process with the family and the patient, a whole investigation within the hospital over possible system issues, one of repeated and also then making changes within their system. And then they also come up with a settlement, okay? They give them some compensation up front. And what it's done is, I know, for instance, University of Illinois in the, I know he's a MD attorney. He's no longer there, but he was able to dramatically reduce the medical legal costs in that medical school, in all their clinical departments by instituting this measure. So to me, it's more, maybe someone says it get rid of the action of the commission, but the big picture is they want to reduce the dollars going out to pay experts and some attorneys on this, and courts and other things. So that was, and it also then it improves patient safety in your own environment. So I think that's how it was initially started. I think Tom and the group is part of that, and he got one of the AHRQ grants relating to reduction of medical legal expenses relating to that. And then this role of trying to, roll this out to the commission, it's just met with all these problems, right? People don't want to talk about their bad problems, right? And make them public. But I just, that's just my feeling about why this was important and why it was initially started. And you hear a lot about it nationally. I was just on a panel a couple of weeks ago, and there was an ENT surgeon from the Harvard Institute. Harvard does this as well. A lot of big hospital systems do this process, they're self-insured, they handle their own medical legal things, and it saves the institutions a lot of money. If you're not in that kind of institution, and then you're sort of excluded. And I think this, is something that, you get people referred to the commission, but they'll get referred by the NPD report, right? It's when you see the settlement that went out in their name. So anyway, just wanted to make that comment. Yeah.
Absolutely, I'm familiar with the whole nuts and bolts of CRP, what's involved, and initially, like I said, Michelle Mello was one of the researchers who showed us the savings that could happen at the University of Michigan Health System, and what the reduction in malpractice dollars were, and the percentages of reduction. I'm mostly talking about what happened for the Washington, what the perception was, both by our leadership, in particular, Dr. Leslie Berger, Dr. Terry, and I believe Dr. Roberts was somehow involved towards the end of it. And so just, in the conversations that had happened, trying to figure out, okay, what is the medical commission's role? And maybe I'd mischaracterize it saying they want to get rid of the commission. A better phrasing would probably be they wanted to make the disciplinary action after the fact by the commission not relevant or not needed, because it was already taken care of. So that's the self-regulation piece that I was referring to. I think that we certainly can, and I don't know what Mr. Rogers is going to say about reducing legal costs, but it should be entertaining. I think the big thing that we've got to be looking at, and you bring it up, is the equity piece. It was a problem for us considering it back then when it started. It's a problem now. If you're not, as you stated, if you're not in a big institution, you don't get access to this. And that was something that we wrestled with for probably the better part of a year, trying to figure out how to make this an equitable resource for everyone. And I'm not sure that we ever did really solve that.
Ed, you've had your hand up for a while. I made you a doctor this afternoon, by the way. So I'll do Dr. Lopez, but go ahead.
Oh, hi. So, as a graduate student, I heard Lucian Leap talk about this, and it really fired me up 20 years ago, back in '03. So I've been hearing this topic for at least 20 years and involved in many, many projects within the hospital systems of Franciscan and now Virginia Mason Franciscan. And I guess what I'm saying is that I'd like to speak on behalf of Ms. De Leon's proposition, which is we need to wait. I think the principles are wonderful. I think, like religion, we love religion, but implementing a change in life is very difficult. And so when it comes to exposing self-exposure and putting ourselves out there because of what we may have done wrong, it's just counterintuitive to who we are as professionals, especially when there's a potential perceived threat. And we need to have, as we've talked so much about in all of our hospital systems, the just culture. Well, if it was a just culture, we wouldn't be talking so much about a just culture. And it's amazing to me how much we talk about a just culture, but nobody, when you talk to physicians and providers, they don't perceive it as just. And so I really think that we should wait before we put a tremendous amount of horsepower in this. It sounds to me like this has been an ongoing kicking the can down the road for 4 or 5 years, and yet, again, nada. So I think we should just wait and see where this is going to go, where the money is, and where the political will is, so that we can get this done properly. Those are my 2 cents.
Thanks, Ed. Appreciate that. Scott?
I agree with waiting. Let's talk to them and figure out what this is going to look like going forward. And if that means rescinding this for now and then going through talks, let's do that. I'm more than willing to help any way that I can with what limited information I have about the medical legal component. I could talk ad nauseum about the problems with the system and why it is, why the institutions are the way that they are. And I've even got some ideas for things that we could propose even through the legislative committee to help facilitate this, and even have discussions with the plaintiffs bar and some organizations there to, along with WISHA and WISMA, of course, to try to remove some of those barriers. And just like Dr. Lopez mentioned before, this is nothing that hasn't been bantered around. In fact, Hillary Clinton in 1993 was one of them who had a big policy proposal on this way well before the IOM report, and she was criticized for using old ideas in the proposals that she had. But there are a lot of ideas here, and there are a lot of people out there. Liz Leadham comes to mind, who would be great at helping assess some of the institutional barriers to putting this together. Legal expenses and time is really, it's not the lawyer's take that is producing a lot of that cost. It's the inherently adversarial nature of our system and the big stakes involved. Perhaps one thing that could help that is to actually put some teeth into a mediation and arbitration clause. And I think that resolving medical malpractice through alternative resolution that does have the teeth of something binding could be one potential thing. Anyway, I'm sorry. I'm going to shut up. I think we should wait, talk, and then revise or come up with a new document.
Any other input or comments?
No, I agree with that completely, as well.
Anybody else that's in this meeting currently have any other comments? So then we're making the determination to rescind this. I need a motion for this, Mike.
Ms. Blake, I I'm not sure the consensus is to rescind, and I would urge against rescinding the document. The document is fine. It's the last
Okay.
section of the document. The document is basically a philosophical statement about principles that are evidence-based, and they promote patient safety. There's no reason to rescind the document. I think it should be revised to update it and to take out the last section talking about disseminating lessons learned, because we're not doing it. I also think the process that we have, the procedure that's in front of you, is a good procedure for handling cases that go through the CRP process, go through the certification process, because cases can still do that, and I think they will. So I don't think there's any reason to rescind it. There's no cost to the commission of having these documents still on our website, still
Well,
alive.
I disagree in that we don't follow the CRP process. We don't do it at all. So, because there are particular steps that have to be taken by the foundation, and if they don't take those steps, we really can't use the process. So that process itself is outdated. So, the philosophy about CRP and all of that is great. But the document is wrong. There is no publication of errors and all of this. So I don't know. I'm not the attorney for the commission, and I don't know if Heather is on here. But should these be out there and, someone say, why aren't you doing this or whatever? But for you publishing, these errors, maybe it wouldn't have happened to me. I don't know if there's a risk of having the documents as they currently are still on our website. I mean, you could take them down and to revise them and not resend them, I suppose, but they're just blatantly wrong. And so I have a little bit of an issue with that.
Before Heather jumps in, I am gonna just ask for a clarification or at least an opinion on this. Is, to my read, more of a procedure, and is it appropriate to run these through policy? Because it says how we will handle a case, right? It's not a policy of our policy is this, this is a guideline, but this is how we will process a case.
There's two documents, just to be clear. There's the guideline, and then there's the procedure.
Right. I'm asking about the procedure.
There's nothing.
Yeah,
there's
technically
nothing in the procedure about disseminating information. There's nothing inaccurate in the procedure.
Right, but the procedure is an operational procedure and really doesn't need to go through policy. So we could take it off and revise it when we get a new procedure and not have a problem. We don't usually come to policy for procedures unless there is a huge amount of work that is done by the commissioners. And I haven't, looked through this, but y'all don't see we have like 200 process maps. You don't see all of them because you're not part of that bit. So technically operational procedures don't come through the policy, but I haven't looked at this close enough lately to see whether or not there is a huge amount of work for commissioners in it. When there is, then we usually have you review it. So there's that. But to be honest with you, if they're wrong, they're wrong. And so we need to revise them, and they shouldn't be published if they're wrong.
Yeah, Melanie, you keep saying the procedure is wrong. There's nothing wrong with the procedure. It's the guidance document that has the inaccurate information in it.
Okay, well then why is the procedure here on the screen? Why am I looking at it?
Because I brought them both to the policy committee because they're tied together. The guidance document is a philosophical statement where the commission is endorsing just culture and encouraging institutions to adopt CRPs. Then there's the procedure, which is how the commission will process a case that's gone through certification. So they're tied together. You can certainly take the procedure and run it internally as you do other procedures, but I brought it forward because it has to be viewed with the guidance document. They have to be viewed together. Otherwise, you wouldn't you wouldn't know what happens to a case that goes through the commission. They should be viewed together, and I thought this committee should take a look at them together. And I think that there's nothing wrong with the procedure. It can certainly be revised, but there's nothing wrong with it. There is something wrong with the guidance document.
Heather?
Amelia, can you unmute her?
I can't unmute her either.
Let me try.
I can't mute or unmute her. I made her a presenter, but maybe if I make her an attendee again. Make her an attendee. Can you unmute yourself now, Heather? I don't know. Can't even find her.
If she jumps out of the meeting and back in again, will that help? Oh, here she goes. She put something in chat.
Okay.
Okay. Okay,
So
so
she
she's,
just, sorry, I'm going to read it. It says, I think it is fine to just table the issue until you gather more information. You may want to just take it down from the web.
It's always helpful to have your lawyer silenced.
um, is, how does everybody feel about that?
One thought that I had was if we could, on the website, have a title and just say that, and not have any content, and just make a statement under the title that it is in process, under revision, so that it is known that we are addressing it or concerned about it, but that we are at least thinking about revising it so that the public understands that we have not, for those who may have seen it before and said, hey, what happened to it? They're aware that at least we're thinking about it and are concerned. My thought.
I'll just jump in the name of the folks that control the web. If you have seen our website where the policies and procedures are, it's not really set up to provide explanatory statements. It's just a list of policies by area and link. And I would say it's, if folks want to know what we're doing, coming to these meetings and seeing the minutes of the business meeting and that sort of thing, and the recordings of them that we're doing, frankly, right now, is probably the best way for them to get knowledge of that. We certainly do send this out on our what used to be called listservs, now it's Gov Delivery, as well as in our newsletter for updates and that sort of thing. So we could keep people up to date in that way. I think a bit more effective than trying to add something to our policy page.
Do we generally take down these things when we update them? I mean, a lot of the ones that we've had on there that we've updated are guidance documents. We just leave until they're changed, right? Mike, is that what's done? Do we take them down?
Yeah.
Yes.
No, we don't. We take them down when they're rescinded. But you can take this down. I don't think there's anything wrong with either of these two documents, other than that the first document, the guidance document, needs to be revised. And I can revise that, bring it to the next meeting. What needs to be redone is the statement of understanding between the commission and the foundation. That is outdated. It's a new world, and we need to reevaluate that relationship if there's going to be a relationship. That's what needs to be changed. That's one thing I did not bring to this meeting, the statement of understanding.
Well, and I would think, Mike, you would have to kind of wait until the new person is on board, whenever that is, and they kind of figure out what they're doing. Because it might, like I said, it might be different nowadays. I don't know.
Right.
So then I'm hearing that what Heather said, everybody is agreeing to table it for now. Get some more information first, bring it back. Do we want to bring it back to the next meeting with a revision? Do you want to wait? Mike, do you want to do that? Do you want to wait until this other person is in place?
Yeah, I don't want to make a promise that I'll have it for the next meeting. I think let's wait until we can have good communication with the foundation and find out where they want to go and reevaluate this, and then perhaps come forward with new documents at some point in the future.
Okay. Do we need to bring this tomorrow? Since we're deferring it ourselves?
You can just say both of these items are deferred.
Okay. That's a quick and easy report. Is there anything else on our agenda? Do we have a hero report? I think we're meeting this week, right?
Tomorrow.
We're meeting tomorrow from noon to 1. We met at the last meeting, the work group met at the last meeting and discussed coming up with questions for the investigators to choose from to put into letters of cooperation to respondents in medical error cases regarding systems change. I think I've sent that out to everybody on the HERO committee. The draft questions, they were reviewed by Adam and by Frida. We also discussed last time bringing back a formal mentorship program for new commission members. And the other thing we talked about last time was putting in our communications with the respondents resources for mental health issues. And frankly, I don't know what we decided to do with that, but everybody kind of thought that that was a good idea. I'm not sure where that's going, but we can bring that up tomorrow as well.
We got wording from Dr. Bundy, and I think it's a done deal.
Yep, we are adding it to all the letters now.
Great. That's all I had.
If there's nothing else and no other comments.
Miss Blake, I do have one thing.
Okay, go ahead, Micah.
I missed you all at panel today. I did want to let everyone know that starting next Wednesday, the enhanced insufficient information process is launching, courtesy of Fatima Mirza. And so there will be a handout there actually is a handout in your CMT packet that you received from Alex today. And it describes the process. Essentially, if you find that there's a complaint that you're reviewing that does not have sufficient information for you to make a decision, there's effectively 2 questions that you need to think about. What information that the complainant would reasonably possess that do you need to make a decision on that complaint? And number 2, if you had that information, would you authorize it for investigation? Because obviously if you wouldn't, then you don't need additional information. So we will be testing that out. There's also within the PDF sort of a process map, so you understand how it's going to be handled. It'll be treated like a reconsideration. So it will be closed and sent, the complainant will be sent a letter. And if they respond, it'll go through the reconsideration process. So those that you deem insufficient information, you'll see them at the beginning of your packet as reconsideration requests. Any questions on that?
Yeah, I had a question. So a lot of times you can't, I mean, you get the information, you still may not want to authorize it, right? If it doesn't, I don't know, I find it hard to not separate the two. So to me, it's like I would never ask for information if it's something that seems ridiculous, right? But if it is something that's serious, I might ask for information when there isn't anything present. But I can't say whether or not I'd really authorize it if depending on what's said and brought forth. Do you know what I mean?
Right. And so that's really just to prevent because we have had in the past folks like, well, I'm just curious about this. Well, is it going to make a meaningful difference in your decision to authorize it or not? That's really what we're trying to get at.
I like it, Micah.
Yeah. Okay.
Fatima.
Thanks.
All right. Thank you.
Anything else? Anybody else? Okay, then this meeting is adjourned.
See ya.
Thank you.
Thank you all.
Thank you.
Thank you.
Thank you.
See you
Good night.
tomorrow.